Hi, my name is Nabil Lang. I'm a registered migration agent in Australia with Red Earth Migration. My topic today is bridging visas and work rights in Australia. The bridging visa is a temporary, non-substantive visa which may be granted to allow you to remain lawfully in Australia while you wait for an application for a substantive visa to be made in Australia, or while you make arrangements to apply for a substantive visa or to depart Australia, or while you wait for a decision from the Administrative Appeals Tribunal or a court. There are many different types of bridging visas, and all must be applied for in Australia, and they only remain valid while you remain in Australia. The exception to this is the bridging visa B, which is specifically granted to enable a person holding a bridging visa B to travel out of and return to Australia. The bridging visa A is one of the most common bridging visas granted. It is usually automatically granted if you apply for a substantive visa in Australia while you hold another substantive visa. A common example of this is where a person who holds a visitor visa applies for a partner visa. The bridging visa A will automatically be granted when the valid partner visa is lodged, but it will only come into effect when the existing visitor visa expires. Most bridging visa A's have unlimited work rights, but caution should be exercised, because in some cases only the work rights which attach to the previous substantive visa carry over to the bridging visa. The most common example of this is where a person on a student visa applies for another substantive visa. In that case, the work rights on the bridging visa A will be the same 20 hours per week as on the former student visa. A bridging visa B is granted to enable a person to exit